Welcome again to our course on biodesign, strategies for innovation and design on bioengineering. Today we're going to take a look at the intellectual property basics topic. So let's start. So the objectives for today, it's going to be to understand the different types of intellectual property protection schemes that there are. I want you to recognize the requirements of patentability and freedom to operate, including practical cases of how to file and specifically how to do this on medical devices. I want you to develop a familiarity perspective on the patent search process, as well as to understand the fundamentals of the US and international patent coverage. I want you finally to appreciate all the issues surrounding inventorship, ownership, and disclosure so you can take a look at doing this later on in your innovation process. If we take a look at intellectual property, you are going to see that there are four main schemes of protection. There are patents, there are trade secrets, there is copyright, and trademarks. For today's class, we're going to focus ourselves on patents. Nonetheless, you should know that trade secrets and trademarks specifically are well-used tools in intellectual property protection for the biodesign process. So what is a patent? A patent gives the owner, it's a legal document that gives the owner the right to exclude others from making, using, or selling patented inventions, which we are going to call practicing a patent. But they do not give the right to practice the patented invention. What this means is that a patent is actually a document that permits you to forego or to actually pursue legal punishments to someone that uses the knowledge in your patent, but not gives you the opportunity to actually use what you have invented already. Thus, while inventorship might be patentable, okay, and the results of the issued patent give you the opportunity to exploit this economical practice, the invention may still infringe a prior patent, which is called the freedom to operate. So take into consideration this, because doesn't matter if you are patentable and you accomplish the patentability concept, which we're going to see later on in this class, you also have to meet with a freedom to operate criteria, which we are going to see in just a few seconds. But thinking a little bit more about what patentability is, well, an invention to be patentable must meet three criteria. It must be novel, it must be non-obvious, or at least in the European countries, it must involve an inventive step, and it must be useful or susceptible of industrial application, as the European patent law states. Okay, so novelty is the idea of having a single, or at least a single, novel feature that makes your tool or device absolutely new in the space. This means that at least some aspect must be totally new, and there should not be any prior art that hinders the ability to initiate that your patent is actually new. Non-obviousness, it's a little bit trickier, but what you have to think when thinking on non-obviousness is that if this concept is obvious, either because of the skills or because of the workflow of someone that is well inserted, or it's an expert in that field of knowledge, if that new thing that you think it's new is obvious for that person that is trained on that specific skill, then it means that does not accomplish its non-obviousness criteria, which is pretty important. You may think as a non-expert in a field trying to do innovation, then that if you create something that it feels non-obvious for you, it should be new. What you're going to encounter, though, is that non-obviousness is more difficult to prove, but it should be met in order for a patent to be issued. And finally, usefulness. So every patent has a commercial sense, and it protects you economically from other people trying to accomplish economic goals with your invention, and so it must be useful. If there is a patent issue that hasn't proved or cannot be shown, at least theoretically, to have a useful application, then it means that it will not meet the criteria for a patent to be issued. Okay, so accomplishing those three things, novelty, non-obviousness, and usefulness, should be in your mind as an innovator when considering on patenting any device that you are creating. But how do you do a patentability analysis? Well, the one that I'm showing here is actually a pretty good example of how you try to find prior art and to see what are the features in your device that are actually non-obvious and novel. As you're going to see, when you have an idea or a concept for a new device, that device is going to have features. And many of those features, if you try to track down those features throughout time, you're going to see that for many of these features, you're going to have prior art that basically blocks or settles a day in which someone else, or even you, thought about that idea and disclosed that idea to the world. But in a device that is subject to patentability, there should be at least one main feature that is novel and unobvious, which means that there is no prior art for which it can be compared over all time. It doesn't matter if it's 20 years, 50 years, 100 years, or 2,000 years. It should be new and unobvious in all that period of time. That was what novelty means, and at the very end, what patentability tries to accomplish. And this is a diagram that in which you can visually accomplish the goal of showing that for that specific feature or group of features, that you don't have a prior art that hinders that ability of your patent to be new and non-obvious. Well, now that we have talked about patentability, we have to also talk about freedom to operate. As we mentioned, there are two things that must be met ideally for you to have a valuable patent portfolio. One is patentability, so you should accomplish novelty, non-obviousness, and utility, but also the freedom to operate part should be in your mind always as you create your patent portfolio. Freedom to operate, or FTO, means whether a particular action that you're doing, such as testing, commercializing your product, or just trying to create a new product with this, can be done without infringing valid intellectual property rights of others within the jurisdictional scope of intended action. That means that basically you should know if there are any patents that you should license before commercializing your product in the nation that you're trying to commercialize this product, in order for you to be within the legal boundaries that you can work with. So what could happen is that even though you may have a patentable concept, a new concept within your device, it may also be required to use some concepts or some science within it, or techniques or tools within the patent that have been patented by someone else. And if that patent does not belong to you, or you don't have a license to use that knowledge, then it means that you don't have total freedom to operate. And thus, you have to license that patent in order to create, commercialize, and test that product. But how do you do a freedom to operate analysis? Well, in the same way as in patentability, you can use some visual tools to actually do this. But what you are going to see, though, is that even though patentability required you to explore through a very long timeline throughout all the years if that concept was new, novel, and useful, freedom to operate only includes you to explore the main features of your device and to see if valid and still protected patents actually hinder that specific feature as commercial viability means. With that perspective, it means that you only have to explore within 20 years time span of the moment in which you want to patent and commercialize that product to see if a patent actually must be licensed in order for you to commercialize a product. So if freedom to operate analysis tries to prove that all the features in your device are free and cleared of all current patent claims. What you're going to do, again, is to try to lay out all the features of your new device and to see if there is any specific patent with claims that actually protects that specific feature, which you must license or buy out in order for you to test or commercialize your product. If you indeed prove that throughout all your searches you haven't found any patent that, or at least any valid patent now, that that has that specific feature protected, and that's also accomplishing all the features of your device, then it means you have freedom to operate. If one single patent that it's still protecting a certain novel concept, and you want to use that device because it's essential for your product to work, then it means that you are not totally free to operate and you must license that product, which is not an unusual practice in industry. But you should know that in order for a patent portfolio to be really valuable and to be attractive for investors and for you in the innovation process of biodesign, you should try to be as free to operate as possible, which means that, of course, you have to patent, be novel, useful, and non-obvious, but you have to also perform an analysis of several patents to know that you are free to operate within the scope of the countries in which you want to commercialize your product. So how do you do this? How do you search for patents? Well, there are many steps in which you can do this. The one that the biodesign process actually proposes is through different stages of refined searching. So first, you start with a very rush basic search in which you are going to try to use current tools of patent searching like Google Search or Google Patents, to try to see if you can come up with any patents of interest. As you're going to see with a basic search, you're going to have a lot of patents that the browsers are going to tell you are somehow similar to yours, but that might not be 100% true. Nonetheless, you should try to see if there are patents of interest within all those searches that you have already done. It's very important that even in basic search trials, you try to be very formal in the way you describe those outputs, trying to mention exactly what were your keywords for the searching that you perform. In that sense, the output of this basic search, or the step one in patent searching, is going to be a lot of patents of interest, and you should classify them and try to get all the citations from those patents to be the input of our next step, which we are going to call the step 2 or refined search process. With those patents of interest from the step 1, you're going to move into a more refined search in which you're going to try to see if from those patents which ones were new, which ones have already expired, or which ones are really not even relevant for your patent or the things that you want to actually patent, or the product that you're going to develop if you are free to operate within that scope. With that search, you of course need again to write down your keywords and to be very formal in how the patents were filtered down. But at the end of the day, you're going to have a list of revised patents of interest, which again are going to be the input of our special search, which is a further, more refined search in a next step of this process. Finally, you're going to have several iterations of what I call a special searching process, in which those revised patents of interest are going to be even more filtered down with more refined key searching processes and tools that you can use. Such tools, for example, include Pantros IP or Syntax, intellectual property search browsers or tools, which are basically software dedicated to compare patent claims and compare ideas synthetically of patents to break down what a patent really means and what it really protects, and to see if a prior patent actually covers that feature or the whole patent that you want to patent or use in your new product. With that, you are possibly going to have a couple of key patents that you are going to have to either circumvent, or you are going to try to choose to pursue an idea that it's not necessarily included in the key features of that patent, which are called claims, that we're going to explore later on in this module. With this, again, you are going to have key patents that you want to be really keen on, on having in mind when you further develop characteristics of your product, or where you define the ones that you are using, so that you create for yourself a space for as freedom to operate. How you go by and actually put all your prior art search and patent search in one single format? Well, one way of doing it should be something like a table in which you put the title or identifier of the things that you have already found. In the case of prior art, those might not be even patents. Prior art might be anything that was disclosed in open media. It could be a YouTube video, it could be a picture, it could be even a paragraph in a blog, in some obscure web page on the internet. And prior art might be just almost anything. And that could be put also in a table just like this. But let's focus for a moment on the way of doing, on putting your outputs of patent searches. So first, for patent, you're going to try to put the title of the patent, or in this case, the prior, or the title of whatever you're trying to describe. Then you're going to put who's the assignee, so who owns the idea, or at least who disclosed the idea. Some of the key claims, in the case of patents, we're going to actually explore a little bit in more detail what a claim is, but you should put your key claims that you think could hinder your capacity to commercialize a product without licensing those patents. Or in the case of prior art, you should put the features that were disclosed in that in that blog or in that video that you think could hinder your patentability. You should put, of course, more formality on this table. So some search items or keywords, the patent number, the web page in which you discovered these prior art, who was the inventor, the ones who disclosed this, and of course the dates in which the patents were approved, filed, granted, or in which this disclosure was made. Why the dates are important? Because in a legal issue, that's going to be the most important factor that it's going to define if the claims are of who are trying to pursue a legal case with you have the reason behind that claims, or if you are indeed protected before that time. So how does a patent actually looks like? Well, here we have an example of a renal denervation patent. So there are two basic things that you're going to see very easily on a patent when you take a look at it. There is going to be an identification block, and there is going to be a description block. In the identification block, you're going to see that there are several things that are going to make that patent traceable. There's going to be a publication number or type. There's going to be an application number and type. There's going to be a publication date, a filing and priority date, which we're going to later describe. It also establishes the inventorship and who's the assignee of that patent. Of course, something very interesting to notice in the identification block is whether the patent has been granted or it's still an application. As you're going to see, not all patents pass from the phase in which they are submitted, so in which they are applications, to the phase in which they are granted. And this because of non-obviousness or non-novelty of the patents, but it could be also because the actual inventors didn't pursue later on the submission of a full patent after applying for a cover sheet or some other types of protections that we're going to cover later on. The description block is a little bit more complex. It includes an abstract, almost always, a background of the invention, a brief description of the invention and the drawings, if any, a detailed description of the invention and drawings, all the claims, which you're gonna see are the key feature in a patent protection, the classification of the claims and patents, any legal events that have surrounded that patent, and citation to other patents or resources for which the patent holds. So if we take a little bit more closely to this section of a cover sheet of patent, you're going to see that it has a code bar and all the identification parts that we have described earlier. And it also includes the abstract in the very first page. If we look at the second part of this page, you're going to see that almost always includes the main drawing behind the patent. Nonetheless, there are some patents specifically for new molecules and other types of inventions, which a drawing might not be submitted because of the characteristics of the patent and because it might not require even a drawing to be patented. Nonetheless, most of medical devices patents might require you to submit a drawing, such as this one, which we are going to explore later on. So how do you go by and create a drawing or an image that is appropriate for a patent? This is very important for you in the biodesign process, because now that you know that you have a compelling problem to solve and some interesting concepts that you want to use for your solution, and if you have done all your patent search and prior art searches, you know that you might be patentable, and maybe you want to actually submit this patent. And how you go by and draw something that is descriptive of that invention? Well, there are technical drawings and there are device pictures, and those are equally valid. A good patent, I must mention, must include both, or at least just technical drawings. But those drawings include all the parts and part numberings of the key features of your device. So if your device has a screen and a button, or a multiplicity of buttons, or a carcass, or specific features that you know are essential for your device to work, then the drawing must include them. It also includes details of small parts that are key to your device. It could include dimensions, or it could include how a certain shape must be accomplished. And it also includes modules if your device has several modules on it. It also will include several views that are distinct and that can give you a very good sense of how the device looks and works, and how it interacts with the user. Device pictures work specifically to give a sense that for the patent examiners that you have actually developed a patent and that you want to actually pursue this, and that you are not just patenting something out of your mind that you might not even have the will to create later on. So, as we mentioned, one of the most important things to consider in a patent are claims. And technically what a claim is the extent of which a protection is conferred to a patent, or a patent protection sought in a patent application. Okay, so claims are the utmost important thing in a patent, and it should be the focus of your writing. How does a claim look like? Well, if you explore a patent, you're going to see in some of the final pages that there is going to be some paragraphs just like this, in which there is going to say something like this: it is claimed that, and there is going to be several enunciations of the key features of the device. Always a patent starts with what it's called a independent claim, and then it's going to follow by several dependent claims, and maybe possibly other independent and dependent claims. As you can see here, the writing of this might look really complex, but you are going to see that we can actually break down what a patent claim is and how it must be written. So let's take a look at these patents, which you can search, at these patents, independent and dependent claims. So the first claim, which is going to be independent, says something like this: a renal denervation feedback method comprising something. And you're going to see that this is something that repeats itself a lot in patents. And what this means is that basically what it's important is what it's after the comprising word. Basically, what it's before the comprising word, it's a description, general description of what you want to invent and what is the device that you are actually trying to protect. So it's a renal denervation feedback method, okay, that it includes, but it's not, but does not only include what you're going to mention. What the comprising word actually gives to you is the possibility that you are legally describing that what you are about to describe. It's the basic things that your patent covers, but that anything that has that features plus anything else should also license your patent, because you're saying this device comprises or includes but does not include anything that has that but also something else. In this case, this is a renal denervation feedback method that includes a method to perform a baseline measurement, but that if it has a baseline measurement and something else, then it means that you have already thought somehow about that idea too. All the dependent claims, you're going to see that they have a very specific way in which they are written. In this case, for example, it says a renal denervation feedback method, so it repeats the same the same sentence before the comprising, but instead of putting the comprising word, it says renal denervation feedback method according to claim 1 or 2. And those dependent claims actually always make reference to independent claims or to even dependent claims. And what this dependency gives you is the ability to specify on features of an independent claim without altering the scope of an independent claim. So wrapping up this, the idea of claims are just like fences. You want to fence the largest piece of land that you can, of course, trying to protect the most special features and not trying to come up with a patent that covers everything in the world. But an independent claim gives you the ability to create the widest fence possible, and then the dependent claims gives you the ability to create little fences that are stronger within that big fence, so that if anyone tries to actually perform something that it's within that big scope of the fence, but also within the scope of other little fences, then you have even more ability for you to actually pursue legal actions from that person that used the patent that you have already submitted. So how do you go by and what is the process of filing a patent? Now that we know what a patent has and basically what you have to accomplish to get a patent, which is again novelty, non-obviousness, utility, and hopefully freedom to operate, and you have to write this document which has claims and drawings and so on. How do you go by and patent this on the US? Well, there is a very established timeline of the things you have to do in order to have a valid patent. So first of all, you have your invention, and hopefully you don't disclose your invention until you file a provisional patent, which is sometimes called a cover sheet, or it could be a thorough document which consists of a provisional protection of your device. From that moment, you have 12 months to actually file the utility applications. And in that, the USPTO, which is the United States Patent and Trademarks Office, has, from the filing provisional time, has 18 months to actually publish on the internet or on their resources that you have a file provisional already going on, so that everybody is aware that you have already patented that or tried to patent that. From the moment of filing a provisional and after, you're going to have, the patent office actually has between 2 and 4 years, and it could be even more, to get actions and give you a response in the sense if in case your patent is granted or not. So basically what you're going to see is that there are very key moments that you have to follow. From the time that you invent something, you should be sure not to disclose the invention in any particularly wide repository of information, because if you file a provisional and you have already disclosed that concept, you may actually create prior art with yourself. It could come the case in which you disclose something or publish a paper regarding your new device or some of the key concepts of your device, and that at the moment that you want to patent that, they are going to tell you 2 or 4 years after that you are not novel, because there is prior art from yourself actually blocking your ability to create a legal document that protects yourself. And that because you never thought that you must not disclose your idea on any media before actually filing a provisional. That doesn't mean that you should not disclose your idea with peers to validate this, but definitely you should not disclose your idea thoroughly or in a patent context without filing a provisional. After that, you have to meet the criteria of the 12 months to file your utility patent, because if you don't, then you're going to lose your ability to actually getting a patent. And after that, you should know that it's going to take a little bit for that patent to be granted, or at least for you to know if that patent was even granted. As you know, even though one of the most important medical markets out there is the US, you should know that one of the very first strategies in the biodesign process in terms of patenting and patent filing should be to submit for the World Intellectual Property Organization to a PCT, which is a patent that covers you internationally until you go into what it's called national phases. In this case, the timeline is somehow similar to the US. Nonetheless, you should know that probably it's better to pursue a WIPO PCT before even applying for a USPTO patent. So again, first, you have your invention, you should not disclose it. You should try to file a PCT, which is more or less like a provisional patent or a patent file that protects you internationally until you decide which countries you want to really apply on. And then you're going to have 12 months to actually submit your US utility application. So this is very important. You submit your PCT, but then you cannot 1 year later submit a provisional. You have to submit the actual utility application in the US, because if you don't, then you're not going to be able to be covered on the US. After the file PCT, you're gonna have 18 months in which the WIPO is gonna try to publish your idea in their servers, and after that, after having that prior date from your file PCT, you're gonna have up to 30 months to actually decide which national phases you're going to try to submit. And those nations which you choose to pursue further patentability and patents should be your key market targets. In this case, after filing this PCT, you know that you're going to create even for yourself a prior art. So it's very important to know that you should try to patent in the nations in which you want to be really protected, and to know in which ones you are not really willing to do that because it's costly. So finally, I must be really keen on assuring you that public disclosure and patenting should be something really on your mind always as you go to business plan competitions or as you disclose your projects in conferences or even within your own programs. It should be really important for you to know that after you have a very concrete concept that you want to patent and that you know that it's novel and obvious and that you have searched for patents to know that it's free to operate, then you should be really keen on trying not to public disclose your invention without any idea of creating or filing a provisional patent in the United States and internationally through a PCT. Because if you disclose, you really are in danger of losing your ability to get a patent nationally and internationally. So with this in mind, we have concluded our very basics on patent and intellectual property. For more information, please refer yourselves to the book on our book on biodesign from Senius in the chapter 4.1. Please take a look at that. It will give you a lot of valuable information in terms of how to do this in the right way. And basically, please try to do this as early as possible in your innovation process now that you have a concept that you want to protect. And with that, we have concluded our topic on intellectual property basics. My name is Luis Soengsen. Thank you for watching.